Welcome and thank you for joining our webinar today. We appreciate you taking the time to join us and learn about the essentials of estate planning. My name is Kara Musa and I'm the Senior Marketing Coordinator at Cope & Barger Law Firm. We have been in business for over 40 years. We have 9 attorneys on staff and dozens of support staff that are highly qualified and happy to serve you at any time. We do have offices all over the state of California and can meet with you in person or through virtual means such as this. Your presenter today is Victoria Horvatich, and she is one of the 9 attorneys within our firm. Victoria works in both estate planning and estate administration. She works mainly in our San Jose, Sacramento, and Santa Cruz areas, but with this new Zoom technology, she can meet with anyone, anywhere. Victoria is a wonderful attorney who knows the ins and outs of estate planning and is dedicated to serving every client to the best of her capabilities. Here she is, Victoria Horvatich, everybody.
Thank you for that introduction, Kara. We're going to be covering a fair amount of information today, so if you have questions, don't hesitate to reach out either during the presentation or we're happy to set up appointments and answer questions for you privately if you need. So today we're going to be covering advanced healthcare directives, durable power of attorneys, wills, the probate process, and living trusts. Right now, times are very unpredictable and can even be pretty unnerving. The last thing you're going to want to be worried about is who can make your medical decisions if the worst happens. An advanced healthcare directive only becomes needed if you're unable to communicate. And there's often a lot of assumption that if you're married, your spouse can automatically make those decisions, or if you become an adult, that your parents are still able to. But actually in 2004, the HIPAA laws changed to where unless you have a written directive, the court would actually need to get involved to appoint your healthcare power of attorney. And if you're in the position where you can't communicate, really the last thing you're going to want to deal with is the court, because you're going to need a medical decision, and that is not then the time that you want any delay. So if you know anyone who doesn't have one, or if you even have a child who just turned 18, please send them our way and we're happy to get them protected. Another document that we talk about is the durable power of attorney. This is one that will function while you're alive but incapacitated. It's where you appoint your agent to manage your financial or legal if you're unable to, and it can always be revoked and changed if you recover, but it can also remain in effect as long as is needed. This is a document that does end when you pass away, however, so it's only going to be valid while you're living. You may have heard a lot about a will and a trust and whether or not you need one or both, and so we want to go through today and make it a little clearer on which one may fit your current needs. So if you're looking at a will, you would need one if you're an individual with no real estate, if you have an estate of less than $166,250, or if you're a parent of a minor child. That $166,000 limit is actually a probate limit. So if you have a will, but your estate is greater than that amount, unfortunately, the estate still has to go through probate, which is something that I really advocate for most people to try to avoid if possible. The purpose of probate is essentially settling accounts of the living and settling the accounts of the one who has passed away. It's also where you're going to be transferring title from the name of the decedent to the person who's inheriting the property or the assets. Probate is a legal process and it follows the state rules. It can cause a very lengthy delay for settling the estate. The control, unfortunately, is going to be with the court and not with the family. It makes private matters now public, and it costs 5 to 7% of the gross estate. What this means is that if you own a home worth $1 million but only have equity of $200,000, that 5 to 7% is still going to apply to the full million. I unfortunately am currently experiencing the probate process, which, trust me, it is lengthy, it's very costly, and it's emotionally draining. My grandma had had her estate done with an attorney she met many, many years ago, and unfortunately an error was found after she passed away. As a result of this, the estate does need to go through court to have the judge determine what the plan is instructing me as the trustee to do. We had a hearing for June 1st, but because of the COVID crisis that's going on, That hearing was actually moved to the end of September, which means we're now essentially just waiting, and it's a bit of a nightmare. So like I said, I really advocate for anybody who can avoid probate to do so. A trust is a great way to avoid probate. It's a contract between the settlor, who's the creator of the trust, and the trustee, who's the manager. So as a settlor, you get to set the terms of it. You decide who gets what when, who manages the estate, for how long. It's yours to do with as you want. And then the trustee's job is to just carry out the settlor's wishes. They get to manage the estate and follow the terms of the trust. They don't get to have any change or say in what happens to it. There are two main types of trusts that we look at. There are testamentary trusts that are created by will and are irrevocable because they're created once you pass away, and they do have to go through probate. We can include the trust for the minor children here, so this is at least a good thing to have if you have minor kids. The living trusts are created during your lifetime, as is mentioned in the name. They can be revocable, which just simply means you can revoke it during your life, or they can be irrevocable, which just means you can't revoke it. We often use these for income, estate, and gift tax protection. So if you have questions or concerns about taxes, please come talk to us and we're happy to give you additional information. The three key roles we look at when we're setting up a trust that we want to fill is who is going to create the trust and set the terms. That would be you or whoever is coming to us to implement a trust. The trustee, which as I mentioned earlier, is who manages and then will invest the trust assets to hopefully have them grow. And it's someone who has to follow the terms of the trust. And this really is important to note because a lot of times people are concerned that after they pass away, that the trustee is going to be able to change the trust, and that is not the case. Once you pass on, the trustee has to follow what those terms were as of the date you've passed away forward. And then the last role is the beneficiary. This is the person or entity that you've named in the trust who is going to benefit from your estate. It can be multiple people, it can be relatives, charities, it's whoever you are leaving your assets to. With a trust, we're really looking to avoid the cost and delay of probate if your estate is greater than that $166,000. It does allow you to protect your privacy because it doesn't become public as we don't file these with the court. We can help you with tax planning. So if your estate is large enough that there's concern of taxes when you pass away, please talk to us because we can do a lot to help protect you and then also protect your family. It will avoid court-supervised guardianships or conservatorships, which we'll talk about a little bit more in a bit. And it makes sure that your wishes and not the court's are carried out. Because if it goes to court, like we talked about earlier, it's the court rules that are going to apply, not your own. One very key thing to note is that a trust only protects what it owns. And so if you set up a trust, it's vitally important that you ensure the assets are now titled in the name of the trust. You can do this not only by just titling them, but we also create a pour-over will for you, which we'll talk about in a minute, and then that durable power of attorney, which I just mentioned. One of the things we offer if you are or become a client is client seminars. If a client attends those, it will get them a free review of their trust and their estate plan. During these review meetings, we're going to confirm that assets are now titled in the trust name so as to avoid probate. We really want to ensure that we have a lasting and lifelong relationship with our clients and that they're going to have opportunities to meet with us to ensure that as life changes, they are still fully protected. So I mentioned a pour-over will a little earlier. A pour-over will is a document that accompanies the trust versus the will we talked about earlier essentially takes the place if you do not have a trust. With the pour-over will, you're going to name an executor so that if you, let's say, forget to title a checking account in the name of the trust, pass away, you've named who would go to the court to say, scoop that asset up and chuck it back into the trust so that the terms of the trust are still followed. It's also where we're going to name a guardian for your minor children, which, like I said earlier, we're going to talk about more in a minute. It's also where you can transfer some personal effects and transferring those remaining assets outside of the trust to the trustee. But it does have to go through some form of probate process to do so. So that's why we really want to make sure that our clients transfer all of their assets into the name of the trust so that it's not an issue. With trusts, there are a few additional protective options that we offer. An AB trust, what happens is that when if there's a spouse, and the two of you are living, and then one passes, it goes from one pot and then splits into two. The 50% of the estate that belongs to the decedent becomes protected in the event the surviving spouse remarries and has a new family, or if there's a concern of creditors and lawsuits. One example for this is that if the survivor is in a car accident that is completely their fault, and the lawsuit is more than they have in their portion of the estate, that lawsuit still cannot touch the 50% that belong to the decedent. So it allows the survivor to have a protected amount of assets so that if the worst happens, they still have something to fall back on. But it also means that the money can't be diverted from who the decedent ultimately wanted it to go to. We also use the AB trust to help maximize tax credits. So like I said earlier, if your estate is of a certain value where you're concerned about maximizing estate tax planning, let us know and we can help set this up. A generation skipping trust is something for your children. Instead of them receiving their inheritance outright, it would go into a protective trust or lockbox, essentially, where your child is the only one with the key. This helps to ensure your wealth stays within your family line and who you wanted it to go to. But it also is going to help protect your children from any creditors, lawsuits, bankruptcy, or the IRS. So that even if they make, let's say, a bad business decision, their inheritance is still going to be protected. It also means that if they're married and get a divorce, that inheritance cannot be taken and considered as part of the divorce settlement. Your child can absolutely still benefit from the assets that you leave, and they can manage it themselves. Or for some, they may not manage money the best, so you can put somebody else in charge of it to protect them from themselves at that point. What this trust also does is that anything left in the generation skipping trust is able to pass tax-free to your grandchildren. So it has quite a few layers to it, and if you'd like more information, we're happy to provide that. Long-term care is a really important part of your planning. We understand right now that times are incredibly difficult, and nursing homes, while never the ideal choice, are even less ideal in the current situation. However, we really want to ensure that in each scenario of your life, no matter how unpleasant, that you are protected to the fullest and have as many options as we can make available. Preventative planning does allow you to have choices for your long-term care options. Under current California law, you can make financial arrangements. With this planning, what we're looking to do is qualify you for Medi-Cal, even if you still have your assets. What we essentially do, to put it very simply, is put a wall between Medi-Cal and your assets so that they cannot use them to financially disqualify you from their program. It also protects against state recovery so that if and when you no longer need the care, they cannot go to your family to get it. So let me reiterate that. If, when you no longer need the care, let's say you pass away, Medi-Cal is unable to go after your family to get reimbursement for the care that they provided you. This planning also helps preserve assets for your healthy spouse. One of the things we hate seeing is all of the resources going to the one of you who needs care and the healthy spouse being left with little to nothing. That shouldn't be a choice that you and your family need to make. You should be able to maximize not only the assets you have, but benefit then from the programs that you've been paying into your entire lives. It also helps ensure that the inheritance goes to your children. You worked really hard for your assets, and it should not have to be diverted to the state just because you needed that type of care. With this planning, you're still able to live as long as you possibly can. When you no longer can, the state is not able to take it away. We're able to protect your savings, the things you've worked so hard to build, no matter how much or little that may be. And it helps ensure, like I said, that more can go to your family or charities or whoever else you want it to go to and not the state. So we're really looking to maximize the benefits, not only for you while you're living, but then for whoever you want it to go to when you're no longer here. We're going to be having a seminar next week given by our own Lloyd Kopenbarger that's going to go more in depth on this information slide, but we really want to that we value helping our clients consider and plan for each part of their lives, no matter how big or small. We're here to serve you to our fullest capacity. So if you have questions, even if you think they may not be relevant, do not hesitate to come in and talk to us, because more often than not, these are going to be very relevant to the type of plan you have and to the type of planning outside of what we do that you may need. Guardianship designations are one of the most intimate decisions you can make. This is where you're going to name who can care for your children if you're no longer with us. This, like I said, is about as intimate as it gets. It will already be a traumatic event if something happens to you or you and your spouse and somebody else needs to care for your children. And the last thing you want is for a judge to get to decide who that is, because the judge may name people that you don't want. And by naming people you want, you can help ensure that your children are taken care of by people that you trust. So please come in if you have minor kids and do not have planning, so that we can, at a minimum, help protect them in the event that the worst happens. With beneficiary designations, there's many different types. But like I said earlier, we don't want to just look at the estate plan that we can offer you through us. We want to look at your long-term care insurance options, because that can be an incredibly important part of your estate plan. Long-term care insurance can give you many more additional options that even our planning cannot. So if you qualify for it, we want to encourage you to look into it. And then your 401k, your IRAs, and your other retirement planning is really essential to your entire life plan. When you pass, your beneficiaries will receive these funds. They work with your trust, and so what we want to do is make sure that you understand the ins and outs of both, so that you don't make a decision that could be detrimental to one or the other. So an estate plan should consist of all of these essential documents. If you or someone you know is missing any or all of these, please reach out to us, because we do want to ensure that each person is protected to the fullest extent possible. I really hate hearing that someone is in crisis and is unprotected, because pre-planning is so vitally important. I actually just received a call a few weeks ago from an old teacher of mine who said that his uncle was in hospice care and had no estate plan. While my staff and I were able to create an estate plan in an incredibly short time, he unfortunately still passed away before we could get those documents signed, and it really broke my heart, because that was a situation that could have been prevented. We strive to ensure that people do not have to experience what my teacher did. The thing that I mentioned briefly earlier is the cost of probate. You often do not know the cost of an estate plan until you need it, and mistakes are unfortunately often discovered only after someone has died. I mentioned my grandma, and with that mistake, it wasn't discovered till she passed away. And it's now, like I said, something that the court has to get involved with. My family is not perfect, so unfortunately, going through court has only maximized the conflict that was already there. It has caused a lot of strife. It means that the beneficiaries of my grandmother's plan have to sit and wait. It means, truthfully, that they have to deal with each other well beyond when they probably should. And it has just created an emotional turmoil that really should not have been there. So working with qualified professionals is an incredibly important thing to do. So if you know of someone who's maybe worked with other attorneys and there's concerns of whether or not they are fully protected, we're also happy to take a look at the current plans that they have them to make sure that they're as up to date and as protected as they can be. Your family decisions are going to be very intimate ones, and no one plan is going to fit everybody. So what we pride ourselves on is creating customizable plans for each of our clients, because like I said, your family is unique and your plan should match that. So that is all I have for today. It was a lot of information. We definitely want to see you for an in-person appointment if you are interested. So Kara, I'm going to turn it back to you.
Thank you very much, Ms. Victoria. Again, we would like to thank all of you for attending our webinar today and truly hope you received valuable information that will help you and those you care about most. Remember, you worked hard your entire life to build what you've got, and whether that is a little or a lot to you, it's worth protecting. Whether you walk away from this knowing that you need a trust, a will, powers of attorney, or if you're just not sure, we're here to help. Now to the good stuff. At this time, we're offering complimentary consultations for all who attended today, and an additional 10% off for any new prospects on any estate planning work. For existing clients, we have new financing options available for any updates you may need. If we didn't get a chance to answer your questions today, we will most certainly answer it during your complimentary consultation. Our team will be sending out an email with the recorded webinar along with an invitation to a complimentary consultation with us. Remember, we're here to help you and appreciate being your expert referral for all your professional needs. Have a wonderful rest of your week, and we look forward to serving you and your family for many years to come. Thank you so much.